Today's question. Buyer gave seller a list of repairs on Form 35R, and seller wife agreed to make the repairs. Seller husband is unavailable and cannot sign the 35R. Can seller wife just agree to give buyers more time on the inspection contingency until seller husband can be located to give his signature consenting to the repairs? If you'd like to push pause to take time to think about the answer or to discuss it in your office meeting, do so. The answer to the question is that the parties can't make any modifications to the terms of the purchase and sale agreement without the signature of all parties, including if we have spouses who make up the buyer and the seller party, then both spouses for both parties have to sign any modification to the purchase and sale agreement. And the assumption in this question is that seller giving buyer more time on the inspection contingency to come up with their negotiations on the list of repairs maybe that isn't a modification to the contract at all. Can't one of the seller spouse members simply do that without the consent of the other? And the answer is no. The time frame for the buyer's inspection contingency is set forth in Form 35, which is part of the original purchase and sale agreement. So this question assumes that seller cannot, without the signature of both seller spouses, modify the contract to obligate seller to make repairs for the buyer. That's a correct assumption. That same assumption, however, extends to the other half of the question, which is, can the purchase and sale agreement be modified to extend the buyer's inspection contingency time period to accommodate the difficulties that the seller is having in coming up with adequate signatures? And the answer is no. In both cases, we're talking about a modification to the underlying contract terms. And if we are going to modify the contract terms, then all members of both parties have to sign that modification. I don't have an answer to this question of what this buyer can do. The inspection contingency timeframe is established. Now, maybe it will turn out that the seller is accommodating because it was seller's difficulty in coming up with an adequate signature for agreement to buyer's inspection contingency repair list. Maybe the seller will be cooperative in that way. But buyer cannot bind this seller to a list of repairs or an extension of the inspection contingency timeframe without the signature of both sellers. So buyer broker, you take a risk in advising buyers to go forward with the signature of only one seller. The risk is that what happens is, with the passage of time, buyer effectively waives buyer's inspection contingency without having entered an agreement for seller to modify the terms of the agreement or to extend the inspection contingency time period, or for buyer to have terminated the agreement. In other words, all of buyer's rights under the inspection contingency go away after the passage of the identified amount of time, and without the signature of both sellers modifying the contract terms, buyer doesn't have a solution. There's not an easy answer for buyer brokers to give buyer in this scenario. Really, all that you can do in this scenario, buyer brokers, is advise buyer of that difficult situation. Buyer, what do you want to do? Do you want to move forward to closing hoping that seller will make the repairs that one of the seller spouses has agreed to make? Or, buyer, do you prefer to terminate this contract, the purchase and sale agreement, and move on to another property where you have a seller who's available, both members of the seller party, to execute an agreement to modify the contract based on your inspection outcome? That's all that the buyer broker can do in this situation, is advise the buyer of the buyer's unsavory choice. And then let the buyer make the decision that the buyer wants to make. The lesson from this question is really overarching to everything that you do with the statewide forms. You have to know the forms well enough to know what the consequences are for your client in any particular form negotiation or contract setting that comes up. And if you don't know what the outcome will be, don't guess. You're going to get yourself, you're going to get your client, and you're going to get your firm into trouble. Talk to your managing broker. If you need to, call your lawyer. Of course, you're always welcome to send an email to me at the legal hotline, and I'll help you work through these questions the best that I can. My email address is legalhotline@warealtor.org. I look forward to hearing from you with contract questions or any other real estate law question that you might have. Thank you for being a Washington Realtors member.